The age of chains and overt coercion, we are told, is a relic, a ghost confined to the pages of ancient history. We have grown accustomed to viewing our society as a pinnacle of humanism and liberty. Yet, if we strip away the illusions and examine the very foundation upon which all modern jurisprudence stands, a starkly different picture emerges. The legal systems of the United States, of every European state, and of most nations on earth are built upon the monumental bedrock of Roman law. It is crucial to recognize what Roman law was at its core: the legal code of a slave-owning civilization. It was a system engineered to regulate relationships in a society where the ownership of one human being by another was the norm. And this structure has not vanished. It has merely adapted. It has changed its terminology and rooted itself deep within the architecture of the modern world. To comprehend the scale of this legal framework, one must look to the economic essence of slavery itself. It is simple, and it is cynical. A free person owns the results of their labor. A slave, by definition, does not. Herein lies the fundamental watershed between freedom and bondage. If one reads carefully the texts of modern constitutions and labor codes, a breathtaking substitution of concepts is revealed. The highest laws of the land solemnly proclaim that labor is free, that coercion is forbidden, and that every person is at liberty to choose their occupation. However, what exactly do these laws guarantee? They guarantee the right to remuneration for work, the right to conditions of safety and hygiene, protection from unemployment. But nowhere is it written that the product created belongs to its creator. Within this system of coordinates, the law recognizes only the right to receive a ration, a compensation for the effort expended. The results of the labor itself are alienated. They do not belong to the citizen. In effect, the contemporary economic model reproduces the ancient Roman scheme, where everything produced by the worker is expropriated and a prescribed reward is issued from the master's hand. The form of this reward is of no principal significance, be it a bowl of stew in the barracks of an ancient latifundista, or a certain quantity of printed, colored slips of paper in a bank account today. The essence of the contract remains unchanged. It is the exchange of one's lifetime and effort for the means of subsistence, without the right to lay claim to the very fruit of that work. This societal arrangement, based on principles honed over millennia, is reflected not only in economic realities, but in the very symbolism of state documents we have been conditioned not to notice. We live inside a system where the legal status of the individual is blurred, and the true state of affairs is hidden behind complex juridical formulations. And if you believe this is merely a game of words, a matter of legal casuistry that does not affect your actual life, you may have simply neglected to ask the most important question of all. In the grand theater of law, words are everything. But what if two of the most fundamental terms used to define our existence, human and citizen, are not synonyms at all? What if they represent two entirely different legal statuses, with two opposing sets of rights? This is not a matter of semantics. It is the key to a hidden caste system, encoded in the very language of our foundational laws. Examine the text of any constitution closely, and a strange duality emerges. Certain articles speak of the rights of the human being. Others speak of the rights of the citizen. And sometimes they appear side by side, joined by the word "and," a grammatical and logical confirmation that they are two distinct legal subjects. This linguistic subtlety has roots that stretch back through the centuries, directly to the rigid, hierarchical structure of Roman society. In ancient Rome, an elite class, the patricians, stood at the apex. They were the descendants of the original founding clans, possessing the full spectrum of rights simply by virtue of their birth. They did not ask for permission. Their status was natural, inalienable. Opposite them stood the plebeians, the vast population, curtailed in their rights, whose lives were governed by a separate body of law. The plebeians did not possess rights by nature. Their abilities were granted, defined, and limited by the state. When this ancient matrix is laid over our modern world, the alignment is perfect. The legal status of a human being in constitutional law corresponds to that of the Roman patrician. The fundamental rights and freedoms of a human are declared inalienable, belonging to everyone from birth. This is the highest form of existence in the legal field. The status of citizen, however, is a direct analogy to the plebeian. Citizenship is a legal bond between an individual and a state, certified by a document. By becoming a citizen, a living soul accepts the duties and limitations written into law, in essence, voluntarily descending a step in the hierarchy. The fact that a slave believes himself to be a free man is, from a legal standpoint, meaningless if he holds the documents of a slave. In the administrative and judicial system, priority is always given to the paper status. You may consider yourself sovereign, but the moment you present a passport, you enter the game playing by the rules for citizens, the subordinate class. The most glaring confirmation that the population is viewed by the system as this subordinate mass is hidden in a term we hear every day: the referendum. The second, historical, and entirely official name for this procedure is the plebiscite. The etymology of this word leaves no room for doubt. It is the plebiscitum, the opinion of the plebs, a decision made by the plebeians. We are left to wonder, in a system built upon these ancient distinctions, what are we when we stand before the state? Are we the human, endowed with rights by nature itself? Or are we the citizen, defined only by the documents we carry and the permissions they grant? The answer determines not just our legal standing, but the very substance of our freedom. To cast a vote in a plebiscite is an unconscious confession. By the very act of participation, the voter affirms their place within the plebeian class, a stratum of society, by definition, deprived of the full rights of a patrician. The past speaks to us in the language of Roman law, but we have lost the ability to comprehend its grammar, mistaking ancient legal terms for common parlance. We exist upon a vast stage, a set where legal fictions have supplanted reality. The individual, endowed with natural law, is obscured behind the mask of the citizen, an entity bound by regulation and statute. This is not a modern sleight of hand. It is a deception stretching back across millennia, masquerading as social progress. But if one were to strip away the thin veneer of modernity from our institutions of state, an ancient and unyielding foundation would be revealed. You may believe yourself to be sovereign, to be free, but the moment you present a passport, you enter a game governed by the rules for citizens, the rules for the subordinate class. One might ask, what became of ancient Rome if its principles remain so vibrantly alive? The answer is as simple as it is unsettling. It never vanished. It merely changed its sigil and the surnames of its rulers. The accepted narrative of history teaches that the Roman Empire crumbled under the weight of barbarian invasions centuries ago, leaving behind only the ruins of the Colosseum and the Latin of a medical prescription. This is a foundational error, a misconception that conceals the true nature of power. For Rome is not a point on a map of Italy. It is not a specific period in time, nor is it an ethnicity. Rome, above all, is a legal framework for society, a universal operating system for governance, built upon rigid hierarchy and the principles of servitude. When history is viewed through this prism, it becomes clear. The empire never died. It merely altered its borders, its name, and its capital, flowing from one form into another, yet always preserving its predatory essence. This imperial succession can be traced with unnerving precision. After the formal fall of the Western Empire, its direct heir became the Eastern Roman Empire, known to us as Byzantium. From there, the baton was passed to the Holy Roman Empire of the German nation, a political entity that would dominate Europe until the age of Napoleon. The terminology of even the modern era betrays this lineage. The infamous Third Reich translates literally as the Third Empire. Logic dictates that the First Reich was none other than the Holy Roman Empire, and the second, the Kaiser's Germany. The titles of the rulers themselves leave no room for doubt. One need not be a linguist to hear in the German Kaiser the echo of the Latin Caesar. In the same way, the Russian title Tsar is but a phonetic adaptation of the very same word. For centuries, the rulers of Europe and beyond wore the name of a Roman autocrat, binding their authority to an unbroken chain of command. The empire is a phantom that haunts the corridors of power, a legal architecture hidden in plain sight. We may have forgotten its name, but we have never escaped its shadow. The emperor's claim was absolute, the right to own human beings as property. This system of dominion was not confined to antiquity. The Russian Empire, too, was deeply integrated into its logic. The state ideology of Moscow the Third Rome was no mere abstraction. The claim to Roman status was encoded unambiguously within the very name of the ruling dynasty, the Romanovs. From the Latin root Roma, it means, quite literally, the Romans. This was not simply a family name. It was a declaration of belonging, an allegiance to a global elite governing the world according to a Roman blueprint. Similar markers can be found etched across the globe. From the name of a nation, Romania, the Roman land, to the countless state institutions that mirror the structure of the ancient Senate and its prefectures. And so, Rome, as a principle of social order, has outlived every revolution and every war. It remains the one true, enduring form of statehood. Politicians may change their slogans, constitutions may be rewritten, governments may transform from monarchies into republics, but the deep structure remains unaltered. It is a corporation, managing resources and human capital. The words used to distract and deceive can be endlessly democratic. But while words may lie, symbols never do. They speak directly to the subconscious, marking the territory of power. If one looks closely, the ancient insignia of punitive authority are not confined to history textbooks. They are right before our eyes, on the facades of state buildings, in the designs of monuments, and on the emblems of security agencies. A legal system cannot exist merely on paper. It requires instruments of coercion and a visual means of cementing its authority in the minds of the masses. The symbols that surround us in daily life are often dismissed as meaningless decor or a nod to tradition. But they are, in fact, an open code, broadcasting who holds power and the rules by which the game is played. Central to this visual language is the fasces. It is not merely a bundle of twigs, as it might first appear. The fasces, or lictor's bundle, is a collection of rods, typically birch or elm, bound tightly by a red leather strap, and thrust into its center an axe, a battle axe known as a labrys. In ancient Rome, this was the supreme attribute of power, first for kings and later for the highest magistrates. It was carried by the lictors, special attendants who served as bodyguards, and, more importantly, as executioners. The symbolism is brutally specific. The rods were for corporal punishment, the axe for the ultimate penalty, decapitation. The fasces, therefore, is the ancient emblem of the state's right to apply physical violence to its subjects. Its very name comes from the Latin fasces, meaning bundle, a bundle of rods, a bundle of people, bound together under a singular, unchallengeable authority, enforced by the ever-present threat of the blade. From it, the political movement of fascism and the Italian National Fascist Party would take their name. And yet, despite the sinister history of the 20th century, this symbol did not vanish with the defeat of Nazism. On the contrary, the fasces remain deeply embedded in the state symbolism of modern democracies. They are there, hidden in plain sight. One can find them in the emblem of the Federal Penitentiary Service, a direct acknowledgement of the continuity of punitive power. They adorn the ornate railings of the Summer Garden in St. Petersburg. They are carved into the facades of government buildings in France, and they stand sentinel on either side of the Speaker's rostrum in the chamber of the United States House of Representatives. It is a global marker, an assertion that a territory is governed by the laws of Rome, where the right of force is fundamental. No less intriguing is another ubiquitous symbol, the scales, or Libra. We are accustomed to associating them with Themis, the goddess of justice, believing they represent the weighing of arguments to find truth. But in the context of Roman private law, the meaning of the scales is entirely different, and brutally mercantile. The scales were a mandatory instrument in the procedure of mancipatio, a solemn ritual for transferring ownership of all things of value, land, livestock, and, of course, human slaves. A piece of raw metal, typically bronze, was placed upon the scales, serving as payment, determining the price of living property. The libra was a unit of weight, the ancestor of the Roman pound, and the currency known as the lira. The scales in a court of law, then, are not a symbol of abstract justice. They are a tool for assessing the value of damages, of property, a system in which the accused themselves can be weighed and measured. This tableau is completed by the very appearance of those who dispense the law. The robes worn by judges and the togas of prosecutors are a direct inheritance from ancient Rome. There, the toga was a garment of privilege. Only the quirites, free citizens, the slave-owning class, were permitted to wear it. For slaves and foreigners, the garment was forbidden. The most distinguished was the snow-white toga candida, worn by those aspiring to high office, from which we derive the modern word candidate. By donning the robe, a judge visually severs themselves from all others present, declaring a superior status, the authority to pass judgment. All others in the chamber, by default, are reduced to the rank of subordinate. These symbols are not mere decoration. They speak a language, a code that points to a more profound and unsettling foundation, the very concept of the state itself. We ask what a state is, expecting to hear elevated answers about a social contract, the protection of a people, a shared cultural identity. But if we strip away these classroom illusions and turn to etymology and law, a more cynical truth is revealed. From the cold perspective of Roman law, there is little functional difference between a nation and a crime syndicate. It is a truth written not in the ink of philosophy, but in the cold calculus of power and property. A system where authority is not granted, but seized, and where justice is not a universal right, but a transaction, its ancient symbols still casting their long, imperial shadow over us all. The most ubiquitous form of state structure on the planet today is the republic. The word itself descends from the Latin expression res publica. Res, meaning a thing, a matter, or property. Publica, meaning public. The traditional translation, the common affair. A noble sentiment, until one draws a linguistic parallel with another, no less infamous Italian phrase, that means precisely the same thing. In Italian, a direct inheritor of vulgar Latin, the common affair, or our thing, is rendered as cosa nostra. Why would a notorious criminal organization adopt a name that so closely echoes a form of government? Or perhaps the question should be inverted. Why does a form of government bear a name so disturbingly close to that of a crime syndicate? The answer is buried in the foundations of Roman law, which posits that no fundamental difference between them exists. A state, a corporation, an armed syndicate, these are merely forms of human association, organized to manage common resources. Roman jurists defined such unions with stark clarity. They were associations permitted to form under the name of a collegium, or partnership. They acquire the right to hold common property, a common treasury, and a representative, a syndic, through whom they act as a single legal entity. This legal formula is universal. It describes the operating principle of any corporation. History is replete with examples where the line between the state and the private company was erased entirely. Consider the British East India Company or the Russian-American Company. These were commercial enterprises that flew their own flags, minted their own currency, maintained standing armies, constructed fortresses, and waged full-scale wars of conquest. The Opium Wars in China, the subjugation of India, these were campaigns waged not by nations in the modern sense, but by corporations protecting their assets. They possessed de facto sovereignty. Today's states are the same corporate bodies, merely scaled and legitimized through a system of international recognition. The essence of such a structure remains unchanged: the efficient management of property for the benefit of its beneficiaries, those who stand at the head of the collegium. Roman law is explicit. The union owns the common things. But in a society built on hierarchies of power, what is the principal thing? It is the people themselves, the population. In this framework, citizens are not participants in governance. They are assets on the corporate balance sheet. The common affair, the res publica, becomes the business of managing you as a resource. And so, the grand patriotic slogans, the calls to national pride, serve as little more than a veneer for the corporate interests of a ruling elite. The modern patricians, who view the territory of a nation not as a homeland, but as their own private fiefdom, operated under a charter gilded with the language of the public good. To perceive the state not as a republic, but as a syndicate, a corporation, is to shatter the very framework of reality. In this paradigm, taxes cease to be a contribution to the common good. They are revealed as a subscription fee, a recurring tribute paid for the privilege of existing on territory controlled by an immense corporate entity. Laws are no longer the bedrock of a society. They become the internal regulations of a company, binding upon its personnel. And here, the most unsettling question emerges. If the state is a corporation, its territory a market, and its resources its assets, then what precisely is your role in this grand enterprise? One might assume the position of an employee, or perhaps a shareholder. But this is a fundamental error. An employee receives a wage drawn from profits. A shareholder receives dividends. You, on the contrary, pay for everything yourself. In the stark, unyielding logic of Roman law. You are inventory, living property. The most chilling aspect of this arrangement is that you signed the contract yourself, entirely unaware of the moment it transpired. The mechanism by which free will is transmuted into legal obligation has been honed over centuries, its dark genius rooted in the principle of voluntary consent. In Roman law, and in all its modern interpretations, an immutable rule persists. Servitude cannot be imposed by force. It must be accepted. For the system to remain stable, the subject must, with their own hand or their own voice, affirm their subordinate status. Historically, this process was shrouded in religious and administrative rituals. Their true meaning remained opaque to the uninitiated, yet their legal consequences were absolute, fatal, and indefinite. Turning to the edicts of the Russian Empire, we find a startling frankness, a clarity now obscured by bureaucratic euphemism. A decree from Peter I in the year 1700 effectively equated baptism into the Orthodox faith with a binding entry into eternal servitude to the sovereign. It was an act of surrendering both soul and body, transferring ownership to the supreme ruler. Later, a Senate decree under Elizabeth Petrovna on August 27, 1747, codified this practice for foreigners seeking Russian subjecthood. The text of the oath demanded the utterance of chilling words. "I promise and swear to be a faithful, good, and obedient slave, and an eternal subject with my family name." The operative word is eternal. The one taking the oath was signing a contract not merely for themselves, but for their entire lineage, consigning their family name and all their descendants to the state's inventory ledger. In this light, the fierce, desperate resistance of people to population censuses and forced baptisms becomes clear. They sensed, on an intuitive level, that these were not acts of salvation or administration, but of legal and permanent enslavement. Today, the raw principle that a subject is equivalent to property has not disappeared. It has simply undergone a rebranding. The modern concept of citizenship fulfills the very same function, binding a living human being to the state corporation. It is a contract signed in invisible ink, an allegiance sworn in a forgotten moment, binding us to a system we never truly consented to understand. The most damning proof of the servile nature of citizenship is the impossibility of simply walking away from it. Attempt to declare that you no longer wish to be listed on the register of any nation. The system will resist with the full force of its being. Legally, you are forbidden from becoming nothing. You are obligated to belong to a sovereign. The procedure for renouncing the citizenship of one country almost invariably requires a guarantee of acceptance into another. It is a transaction governed by the rules of inventory, of property. Property can be sold, transferred, or bequeathed, but it cannot simply walk into the wilderness and declare itself sovereign. Here, we unearth the true meaning of a word we have been taught to cherish: emancipation. It is a term most mistakenly believed to be a synonym for freedom. The great movements for suffrage, for the rights of minorities, have often marched under its banner. But in Roman law, the source of the concept, emancipatio, was a procedure for establishing ownership. From manus, the hand, and capio, to take, to be taken by hand. Consequently, emancipation was never a release into freedom. It was a transfer of ownership. A slave undergoing the procedure, a woman leaving the wardship of her father, they were not set free. They were merely assigned a new master. In the modern context, this translates to a shift from private dependence to state dependence. By stepping out from the authority of the family or the tribe the individual falls under the direct dominion of the corporate state, becoming its immediate asset. The passport in your pocket is not a key to a world of opportunity. It is a certificate of belonging, an inventory tag bearing a number, confirming that its holder is an object of the law, not its source. We consent to these terms, accepting documents and signing ledgers, believing it to be the natural order of things. We take pride in our status, convinced we are the pinnacle of evolution. But the most profound trap is not hidden in laws that can be rewritten, nor in passports that can be burned. The cage is built from the very language we use to describe ourselves. We call ourselves Homo sapiens, and we pronounce it with pride. But to translate this Latin honestly, to cast aside the comforting euphemisms of our education, is to feel a deep and unsettling chill. For the true meaning of the term shatters the final illusions of our own grandeur. Biologists and anthropologists have conditioned us to see this name as our crown. Wise man, the apex of creation. Yet Latin is a language of unflinching precision, a cynical tongue that suffers no ambiguity if one knows its true roots. Let us dissect the term. The word homo does not mean man in the noble sense we imagine. Its etymology digs deeper, into the soil itself, into humus, the earth, the dust, the mud. It denotes a thing of the earth, a terrestrial object. The most shocking revelation is not found in a legal code, but in the linguistic analysis of the very name we so proudly claim. We are taught it means wise man, a testament to our intellect. But the language of empire is brutally honest. We are the knowing earth, the property that is aware of its own classification. The final illusion to be shattered is not that we are bound by states or by laws, but that we were ever truly separate from the soil from which we were claimed. In its deepest sense, the word homo does not mean man in any noble sense. It means of the earth, one made from the soil, from humus. It speaks not of a planetary resident, but of a biological substance, organic matter. In the cold calculus of Roman law, the term homo was often a synonym for a slave, a creature stripped of legal personhood, a thing. A free man, one who possessed rights, was called a vir, a hero, a man of standing, never homo. And so, the very first word we use to define ourselves casts us down to the level of animated soil, a fertile medium. But a far deeper chasm opens when we analyze the second word, sapiens. We have been taught it means wise or rational, yet its etymological root lies in the verb sapio. Consult a comprehensive Latin dictionary, and the primary, direct meanings are not of the mind, but of the senses. To have a taste, to savor, to smell of something. The notion of being wise is a later, metaphorical extension, the idea of having good taste in judgment. The suffix ens in Latin forms a present participle. Therefore, sapiens literally means tasting, flavorful, or even nutritious. When we join the words, the image that emerges is not wise man, it is flavorful earth, nutritious humus, a biological resource possessing certain palatable qualities for whoever conceived of the name. This interpretation forces us to view history through a chilling new lens. Consider the trial of Christ before Pontius Pilate. The Roman procurator brings the scourged prisoner before the crowd and utters the immortal phrase, ecce homo. Church tradition translates this as, behold the man, a declaration imbued with pity, or perhaps tragic majesty. But Pilate was a Roman official, adjudicating by the unyielding laws of the empire. For him, the legal status of the accused was paramount. A Roman citizen, a vir, could not be flogged and crucified without a specific decree from the Senate. By declaring ecce homo, Pilate was not making a philosophical statement. He was delivering a legal verdict.
Behold the slave.
He was affirming that before him stood a rightless being, a thing, a homo, subject to the full jurisdiction of slave law, an object that could be disposed of at will. The crowd's fury was ignited not because they saw a man, but because this legal status obliterated any claim to royal authority he might have had. If we accept this logic, the entire edifice of Roman law and its modern descendants try manual. The patricians, the fathers, perhaps saw themselves as a separate order of being, architects of a system where the general population is a renewable resource.
We are the humus upon which their prosperity is built.
And this may not refer merely to the fruits of labor or taxation, but to something far more sinister. Something connected to the very life force we yield to the system. Suddenly, the defiant cry, "We are not slaves!" sounds tragically incomplete. It seems we are not merely slaves. We are sustenance. And the grand design is engineered so that we may never realize it, taking pride in the beautiful, gilded labels affixed to our cages. As the fragments of this colossal mosaic assemble, we are faced with a chilling yet inescapable conclusion. Roman law is no dusty artifact of history. It is a perfectly refined operating system for global exploitation, one that has run without failure for 2,000 years. It has outlasted the fall of empires, the shifting of faiths, technological revolutions, and world wars. The secret to its survival lies in a genius act of mimicry. In antiquity, the chains were of iron and visible to all. Today, they are juridical, forged of paper and of code. The system evolved from crude coercion to the sophisticated management of consent. A world where the slave now strives for the brand of citizen, seeing in it protection and privilege, never realizing it is merely the seal of ownership. The true depth of this snare is revealed through the linguistic traps set at every turn. Even the very concept of freedom, which we so cherish, has been subverted. In the English language, the modern lingua franca, two terms exist: freedom and liberty. We are told they are synonyms. Legally, they are antonyms. Freedom is the state of being free by birth, a natural will, requiring no permission. It is the status of a sovereign or a wild creature. Liberty, however, derives from the Latin libertas, the status of a freed slave or a sailor granted shore leave. Liberty is a freedom granted by a master. It is temporary, confined by the boundaries of the permissible, and, most critically, it is revocable. The Statue of Liberty, then, is a monument not to freedom, but to liberty. It celebrates the regulated rights of a subject within a system. We fight for civil rights and liberties. In essence, we are fighting for a longer leash, never once contemplating how to remove the collar. To exit this matrix is nearly impossible, for it now blankets the entire surface of the planet. There is no longer any unclaimed land. Every square meter is the territory of one state corporation or another. You cannot simply stand up and walk away, because beyond the legal field of one corporation, you immediately fall into the jurisdiction of another. The passport is not your identity. It is your pass between the barracks of a global camp.
Your identity, your living essence, is of no interest to the system. It is concerned only with your persona, your legal mask. From the Latin for an actor's mask, which you don upon entering social relations. It is the mask that is judged, fined, and taxed.
But it is you, the living being, who pays. With your time, with your life's energy. Now that this layer of information has been peeled back, an unavoidable question confronts each of us. Who am I now? For knowledge is an irreversible process. You can no longer look at your passport, a courthouse, or a tax form with the same eyes. Where once there were familiar symbols of nation and authority, you now see only the architecture of control. And you are forced to wonder, what, then, is the true meaning of the world they have built around you? You will begin to see the symbols of power for what they truly are. The bundled rods of the enforcer, the hidden brands of the owner. In the very word human, you will hear the faint echo of the soil, a thing to be cultivated, a resource to be harvested. This knowledge is a crushing weight, yet it is the only key to a genuine awakening. To become conscious of one's true status is the first step toward altering reality itself, even if, at first, that reality is only the one within. But a warning must be issued. The system does not tolerate those who perceive its true architecture. By declaring your own sovereignty, by attempting to sever the unseen contracts, you enter into direct opposition. You challenge a mechanism that has spent thousands of years perfecting its methods of suppression. And so, the ultimate questioner, resource, to shoulder the immense responsibility that authentic freedom, not the hollow promise of it, demands. Or is the comfortable cage, with its guaranteed portion and its phantom rights, still preferable to the cold, unforgiving winds of the real world? The answer to that now resides in you, and you alone.